Good morning, everyone. My name is Kerry Craig, and I am your host this morning. It is a pleasure to have you participate on today's webinar, COVID-19, its impact on housing in Indiana. Before I turn over the webinar to Jadira Hoptree for a welcome, I just want to mention a few housekeeping items. First, all lines muted. And if you'd like to ask a question, there are two ways to do so. You can use the raise hand icon on your screen. We will unmute your line and you may ask your question or questions. You can always type your question or questions in the Q&A box, which is also located on your screen. We all know that technology can be trying these days, especially while working from home. So if you lose your connection, you may also reconnect using the link emailed to you. Finally, if you are a Prosperity Indiana member, after today's webinar, you can find both the presentation and recording available on our COVID-19 Resources Hub located in the member portal. And now I wish to turn it over to Jadira Hoptree, Vice President and Community and Economic Development Manager at Fifth Third Bank, for a welcome. Jadira?
Good morning, Kerry, and good morning, everyone. Hope that everybody had a restful weekend. Once again, I want to take a moment to say thank you to Prosperity Indiana team for hosting this important webinar. Your work and dedication are definitely making a difference. I keep hearing it around through the other webinars and phone calls. So really, thank you. Fifth Third Bank, as I mentioned before, has also been supporting our communities for over 160 years, and we plan to continue. At Fifth Third Bank, we have deployed funds for human needs, micro-lending programs across the state, and webinars like this. This week alone, we plan to announce another $250,000 on deployment. One resource also that we have deployed, and I'm pretty excited it's working, so I want to take a moment to mention it again, is the Next Job program that I mentioned at last webinar. The Next Job program is a software that leverages the latest tools and teaching to empower job seekers. The program is now offered free to community organizations to use it with their clients and neighborhoods. Few of the Next Job program's components are the access to the online job search training software, ongoing training with other organizations and tools for effective use of the program, and an opportunity to win scholarships for 2-month or virtual one-on-one job coaching. As I mentioned, this program is showing some success, and for example, we gave 2 job coaching scholarships last week, and 2 individuals also found jobs. And actually better paid jobs that they've had before. So I'm excited to celebrate that. If anybody else wants some information about this program, just reach out to me. My information is on the screen. Also, you may have heard that we are hiring for close of 1,000 customer service positions. Right now in Indiana, we have 7 positions open. So feel free to go to the website of 53.com to learn more about those. We really take seriously our role in helping our community to get back to work. And this is one way of creating more of these opportunities with jobs that might offer a new career and comprehensive benefits. For example, one of the jobs that we were able to place last week is somebody that works in the restaurant business and has been thinking about making a career move. And this opportunity came up and they're going to take it. So hopefully that will be something that we can celebrate in the future. But we will stay in touch and continue to be at the forefront of sharing our best practices and expertise through this time. Again, we are grateful to Prosperity Indiana for gathering us together to provide information and resources. We look forward to listening today and learning more throughout the webinar. Thank you, everyone, and be well. Kerry, back to you.
Thank you very much, Jadira, and thank you to our partners at Fifth Third Bank for making today's webinar possible through the Strengthening Our Communities grant program. Also, thank you to Fifth Third for allowing us to pivot these webinars during this particular crisis to focus on issues that matter to communities and to organizations as they work through COVID-19. So thank you, Jadira.
Oh, you're welcome. Thank you.
So founded in 1986 as the Indiana Association for Community and Economic Development, Prosperity Indiana has mobilized hundreds of members and thousands of people to create economic opportunities and improve social conditions, particularly for those who are most disadvantaged. Prosperity Indiana is a statewide intermediary organization with a local focus. We are a membership organization designed to strengthen communities and improve lives in rural, suburban, and urban areas in all of Indiana's 92 counties. Members provide housing opportunity, they meet basic needs, they connect Hoosiers to jobs, they create vital places, they do all of this and a lot more. Our members represent human services, the arts, legal aid, workforce development, real estate, health services, financial institutions, philanthropy, all levels of government, community action, community housing development organizations, and local economic development groups. We impact communities by promoting comprehensive community development efforts across the state, which include social determinants of health and encourage inclusive growth. We also impact individuals by fostering innovation and financial capability and asset building strategies and increasing opportunities to access resources. And finally, we impact organizations by improving member capacity to impact communities and individuals and track the progress of their efforts. Our mission is to build a better future for our communities by providing advocacy, leveraging resources, and engaging an empowered network of members to create inclusive opportunities that build assets and improve lives. So we do this through 4 different areas: resources, such as delivering training, direct technical assistance, and financial support to organizations and groups. Engagement, we bring people together, including residents and practitioners, to support one another. Advocacy, advocating for policies that support member work and keeping members informed of policies at the state and national level. And finally, through some of our signature programs. And now I would like to turn today's presentation over to Brandon Beeler, Director for the Housing Law Center at Indiana Legal Services. Brandon?
Oh, great. Thank you, Carrie. Hi, everyone. My name is Brandon Beeler. As Carrie said, I'm the Director of the Housing Law Center at Indiana Legal Services. And if you want to go to the second slide or whatever that is, the next slide. So today, this is an ongoing, continuing situation. We don't know much now other than what the state of the law is based on the stimulus packages and the moratoriums both in Indiana and federally. But so I'm going to try to present as simply everything that we know now, some issues that we're seeing now, as well as some things we anticipate we might see once the federal moratoriums are over. And here is, and I'm sorry, Carrie, I think I put animation in these by accident. So this is just sort of the overview slide of what we're going to look at today. And I do want to open up the time at the end and I think I've hopefully left ample time for folks to get some questions in and or really do some information sharing if there's something that you're seeing or that you've seen that tenants are facing that I didn't address. This is a great platform and time to do that. And so I certainly want to say thank you to Prosperity Indiana for having these weekly conversations, not just on housing, but all the different areas that Hoosiers, and especially the most vulnerable low-income Hoosiers, may face based on this COVID crisis. So we can move on to the next slide. Yep. And then if you want to go ahead and put all the points up there, that'd be great. So we don't have to do that. Thank you, Carrie. So first, we're going to talk about the Indiana eviction, and it is a moratorium. But one way to think about it is kind of what we say on our website is the eviction pause. I think that's a healthy way to think and to kind of realize that, it's not like anything during this period stops a tenant from having, liability to the landlord, or the landlord having future claims for possession against tenants. So it's more or less to think of it in that sense of that currently, currently a landlord cannot file in Indiana to evict a tenant. So in Indiana, the eviction moratorium was initiated on March 19th. And as of today, and that's why I put that on there in case we use these, in case someone refers to these slides later, as of today, the Governor Holcomb's executive order has been extended through May 5th, 2020. The governor said in initiating this in his speech on the 19th of March is that, quote, no residential eviction proceedings or foreclosure actions may be initiated during the public health emergency. This does not relieve the individual of the obligation to pay rent or to pay rent or mortgage payments. Specifically, the governing executive order states, it is reasonable and necessary to suspend laws relating to real property, including breach of leases and mortgages, to control the occupancy of the premises in the disaster area, which is the entire state of Indiana, and to impose a moratorium on both evictions and foreclosures. So this is the language from the governor's order. And the highlight there too is, again, tenants are still obligated to pay rent. And that's just, and so that's something that I understand that I'll address this towards the end of the presentation, that, understandably, one of the reasons for the moratorium is that many tenants, especially the low-income tenants, have hourly jobs and may have lost their jobs during this, so they may not be able to even afford rent at this point. So I'll talk about some solutions, or some proposed solutions, I should say, then. If you move to the next slide, please. Thank you. So I want to comment quickly on Indiana courts. I know not everyone on the phone's a lawyer deals with this, but this is just sort of a kind of give you a snapshot of what Indiana is specifically doing here. So the Indiana Supreme Court extended its emergency order, which that extends until May 4th, 2020. Essentially what this does is just allows each county court system to make special emergency rules and, and delay, which means kind of continue non-essential court matters. The rules do change county to county. So I know that since Prosperity is a statewide group, there may be people who are not here from Marion County or the surrounding counties. So it's important to look to your county emergency orders. You can find those that the Indiana in.gov/judiciary, I think has a COVID-19 resource page, and actually on there you can see each county's specific emergency orders. It's done under Administrative Rule 17. You'll see AR 17 referred to on that site. So if you want to know what your county specifically is doing as to scheduling court matters and what their procedures are, I advise you to go to that screen at the in.gov/judiciary. Courts are being encouraged to hold virtual hearings. That's happening, and again, they're trying to really only limit those to emergency matters. And with that said, again, they can do emergency matters, and that is kind of a speculative or a subjective standard of what is an emergency. We do not think, and I think the governor's order makes it clear that lease violation evictions are not emergencies, and that's obviously can't be filed on during this time. We don't know what if there's if landlords start to get restless during this time, if they're going to maybe try to do something under the guise of emergency, but I've not seen that yet, and hopefully that wouldn't be the case. But I just want to kind of highlight what the courts statewide are doing, and again, you'll have to look specifically to your county and what they're doing. Next slide, please, or next two slides, I guess. Thank you. So this is now kind of talking about the federal eviction moratorium, and I tried to break this down a little simply, and hopefully it's just will give you a snapshot of what's happening here. So on March 18th, the president announced during one of his daily press conferences that HUD was going to issue an eviction moratorium. This was limited in scope. Later that day, HUD issued a reg that said basically that there was an eviction moratorium on FHA insured mortgage properties and FHA insured single family properties. So this really didn't affect a lot of properties, at least that I see. But it's good to know that that's still, as far as I know, active and still an active reg. Larger, on March 27th is when Congress passed the CARES Act, the coronavirus stimulus package, and that did have and implemented the federal eviction moratorium on certain covered properties. And that's sort of vague. And what the language is on covered properties, and I'll get into more, I have more detail on that in the following slides, but the covered properties under the CARES Act states that a covered property is one, where participants in a covered housing programs as defined under the Violence Against Women Act, or VAWA. Two, participates in the Rural Housing Voucher Program under Section 542 of the Housing Act of 1949. Three, has a federally backed mortgage loan. Or four, has a federally backed multifamily mortgage loan. So with the CARES Act, as we'll see in a second, it does impose a moratorium for a significant amount of time, and it also includes heightened notice provisions, which I'm going to highlight because those I think will be important as we kind of see this play out, especially in the months following when the moratorium's lifted. Next slide, please. So again, those four categories I mentioned under the CARES Act, how we're getting most of the properties that we see, and especially here at Legal Services, and that affect probably the most vulnerable Hoosiers, come under this VAWA, the VAWA covered housing programs. So I actually want to highlight all of them. A lot of them I've not actually dealt with myself, but a lot of them I have, and I think that if you all see them, it's just important to have a comprehensive list. So that's what I tried to do here. Is this is really supposed to be a comprehensive list that if you need to refer to this slide, you can. So you know the big players, the common ones being the public housing program, the Section 8 housing choice voucher program, Section 8 project-based housing, and going on and read all of them. But those are all the ones that are covered through VAWA. And under HUD that are covered. Next slide, please. Again, also under the VAWA, how you get the VAWA coverage is going to be under the Department of Agriculture. These are certain rural and labor housing, farm labor housing. So Section 515, Section 514, 533, and 538. These are all covered. The next slide. And then the big one under the Department of Treasury, it's the LIHTC, the Low Income Housing Tax Credit Program. These properties are also covered properties. Next slide, please. And finally, again, just to be comprehensive, these are just the other three categories of covered properties that I'm not going to elaborate too much on, but I just want to make sure to have them here so you can have the participants here can have a focused list of covered properties. So thanks. Now, next slide, please. So again, the CARES Act eviction moratorium took effect on March 27th. 2020. It extends for 120 days, so no filing of eviction on any of those covered properties for 120 days, which adding that up means July 25th. At this point, again, as of today, April 13th, July 25th is the first date that that these covered properties can start the eviction process, is how I'm going to say it, if there's a reason to evict. It's specific to know that under the CARES Act, the moratorium is aimed at specifically from filing new actions based on non-payment of rent. So this is language we're kind of going to have to go under and follow. But I think for advocates and for our clients especially, it's worth noting that we want to assert that the moratorium bars filing of any eviction case that is motivated wholly or in part by a tenant's non-payment of rent or for other fees charged, whether or not the action is formally based on non-payment. So I think what that really means is kind of looking for the reasons to say that everything can kind of be tied to non-payment, or at least non-payment due to the COVID crisis. Another protection under the CARES Act moratorium is that landlords are prohibited under the covered properties again, are prohibited from charging additional fees, penalties that are related to non-payment of rent. So it's very clear to that. So even this should trump any sort of lease provisions as far as late fees and things under the stimulus package. So it's important to note that if clients now are looking at their or I should say tenants are looking at their online account ledger, and late fees at this point should not be piling on due to the inability to pay rent. Again, I just need to be clear. Tenants are obligated to pay rent. There is a debt for the rent payment, but additional fees are not permitted at this point. Next slide, please. So the other thing that I don't want to neglect, because this is going to be a really, I believe, important part, an important protection for our tenants who may find themselves unable to pay rent because of the COVID crisis right now. There's a 30-day notice requirement under the CARE Act. So these covered properties, come July 25th, assuming that's when the moratorium ends, can't just on the 25th file an eviction. There's a 30-day notice requirement, and that notice cannot be given until after the period ends. So at this point, a landlord could not even give a tenant in a covered property an eviction notice or a notice to quit until the 25th of July. Again, remember, the CARES Act does limit the scope to this being non-payment issues. But again, like I said, I think if you look closely at what happens in a lot of these cases and really kind of pull the strings apart, you can find that pretty much most things can be tied to non-payment. I want to make a quick note on due process. That's what this notice is. This notice requirement is simply enhancing a tenant's due process in their protected property interest of their rental house. So this means that the landlord, if they fail to provide this notice that's required under the CARES Act, and they just file an eviction on July 25th, it should be grounds to dismiss the case in a court by citing the act and saying that the notice provision wasn't followed. So that should be what happens. Again, it's too early to determine what's happening with that, but that's just something I want to make sure that everyone on the call is aware of. And finally, relatedly to due process, these covered properties are all federally subsidized in some way or another. And with that comes varying levels of due process that tenants are already entitled to simply by living in those properties. So for instance, in public housing, there's already a notice requirement prior to terminating a tenancy, and the tenants have rights to a grievance hearing and to challenge a proposed termination of their tenancy prior to even seeing or going to court. The same for the LIHTC program. The LIHTC program has a good cause requirement before terminating a tenancy or making the decision to renew the lease. There's a good cause requirement. So I just want to point that out, that still exists, and we need not forget about those protections. This CARES Act is just another protection added on to these different programs. So for those, you're just going to have to look at each program you're in and try to figure out what protections already exist. Next slide, please. So what we're seeing now, this is really going to be a brief survey of just what I've personally seen so far that's come in through my organization at Indiana Legal Services, and what I've also heard from other community partners, kind of the most common issues. And I tried to really just pare it down to the big ones. But again, I certainly hope that through just continued discussion and or potentially questions and things at the end, if there's other issues happening, I think again you'll hear my big push for resource sharing, because I do think that's probably one of the most important things that we all can do right now. So the first one is going to be hotels. So hotels, that kind of on day one has been a problem throughout the state. So hotel residents are not regulated under the landlord-tenant code. It's actually specifically excluded that staying in a hotel does not create a landlord-tenant relationship. Therefore, hotel residents are not entitled to the protections under the Indiana's landlord-tenant code, nor to the federal moratoriums. At this point, it's been sort of not necessarily a legal solutions. It's been more practical and relying on the generosity of private community partners, including even places of worship that have started tenant assistance funds that help pay for people who are living in hotels and try to cover their bills, because we don't have additional protections for them for hotel residents at this point, even in extended stay hotels. However, there is a part of Governor Holcomb's executive order that does point out, include, and state specifically that hotels and motels are considered housing for the purposes of the order. So that is a point that we're aware of, and that if we should this get to, or should we find a situation where we want to start trying some legal advocacy? Because again, I think the ones I've seen, I've been fortunate enough to informally resolve them, but I know that's not the case for everyone, and I want to be mindful of that and try to get out in front and again provide the community with the resources we can to fight that. So, or to help that, I should say. So we are thinking and talking with other even legal aid organizations about potentially getting injunctions and filing for injunctions in these cases based on policy and citing the governor's language about the hotels being considered homes, because again, obviously it's bad public policy to or I should say I would think most would think it's bad public policy to boot people out of a hotel even and make them be in public, or potentially at worst be homeless during a global pandemic. So that's advocacy. Again, as you'll see, everything's working and a continuing work in progress. So hopefully we can continue I'll happy to continue to update you all on what we're seeing and what's successful and maybe what's not successful. Yeah, next slide, please. So another issue that's come up a few times are writs or judgments for eviction that happened before the March 19th order. So one thing that's sort of unclear, and this is going to depend on your county jurisdiction, and it's not always clear or necessarily even put in writing, is questioning whether constables are executing writs. So I guess I should explain the situation. This is a situation where the tenant went to court or had an eviction hearing prior to the governor or even the federal government issuing any sort of moratorium. So a judgment's been entered, and perhaps they delayed it a few weeks or even delayed it a month or two, and so there's this active judgment that could be executed, and what we're doing about that. So I think the first question is trying to figure out whether constables are executing writs. I've spent a lot of time, and some of our support staff in our office have tried to just simply call around, and I don't unfortunately have a really good answer for you on that. I think in Indianapolis, it varies, be it by township, what each constable is doing, and statewide, it's probably going to vary county to county. Again, obviously, we think there's not great public policy for executing a writ, but if you happen to have a tenant or know a tenant that did have an eviction order entered against them prior to March 19th, one thing we're thinking and we're advising is potentially to seek a writ of the eviction. You can find, the court offices are still all operational. They are a lot of the court staff and bailiff and clerks are working remotely, but they should be able to answer questions and help make filing easy. So even if a tenant doesn't have an attorney necessarily, there should be procedures that will help folks just get that in and see if a judge will at least stay a writ during this pandemic and at least during the course of the moratoriums. It's also worth noting that most writs expire after 30 days. So even if there is an active writ out, it should, most of them, we've been in this, we're not quite to a month, but I guess that's the other thing too, is just seeing those expiration dates and making sure that maybe a landlord got a writ prior to the 19th of March, but didn't exercise it yet, and it's not active anymore. So that's another thing just to look at, is seeing when those, and that should again all be accessible through the public records. So if you go to mycase.in.gov, you can search the tenant and search the writ, and you again should be able to see the writs online. Next slide, please. And finally, with well, in this section, with ongoing concerns, these are things I have not seen or actually heard of, but I am concerned could be happening or will happen, especially as this continues on and depending on the relationship between the tenant and the landlord, if landlords, start to get more frustrated as we all continue to hunker down. So one is self-help evictions, concern about lockouts and landlords displacing tenants on their own without going to court. I guess it should go. Well, I guess it shouldn't go without saying that that is not lawful, and that even in normal circumstances, in Indiana, landlords must get a court order before evicting a tenant. So that's one thing to look out for. There are some legal solutions here. Again, those are some the tenants may have. Well, I guess I'll go on to the next with the bad use of it. The other thing I'm concerned about is improper invocation of the emergency possessory order statute. So the emergency possessory order statute under the Indiana Landlord Tenant Code, which I should say, since the statutes were suspended, it is questionable whether this is even an active statute at this point, but we will see. But so the emergency possessory orders, sometimes, and even again in the normal course of events, landlords have used them incorrectly. It is supposed to be limited to when a tenant is committing physical waste, which means actual damage to a rental property. So it's devaluing the price of the property, and it's something that would qualify as an emergency to get a tenant out quickly, because a landlord should not have to suffer damage to their property, and that makes sense. But I've personally had cases that landlords have used the emergency possessory order for threats to management or other alleged actions like that don't deal with that, and that's something I just want to make sure is communicated to everyone, that that's not what the emergency possession statute is for. It is for physical waste to property only. Otherwise, landlords must go through the standard typical eviction process, because with an emergency possessory order under the statute, once it's filed and declared emergency by the court will schedule a hearing within 3 days due to the nature of the emergency. So just kind of keeping an eye out for that in case local county courts are going to start accepting emergency possessory order statutes. So the emergency possessory order can also be used by tenants. I didn't really address that on here because, again, I think we're trying to limit any court filings at this point, just for the safety and health of both tenants, landlords, and the court staff and everyone in general. But with lockouts, that's one example. That's one area where tenants can use the emergency possessory order to try to get emergency relief. So it'd be lockouts if a landlord shuts off utilities or things like that. That is a theoretically available cause of action. And finally, which I think I mentioned 1 or 2 times later, is concerns about retaliation. I know that everyone's very much on edge right now, and from my perspective of working with low-income tenants, it is also good to remember that tenants, even during this, are still entitled to their basic protections. They are, in the most obvious one, they are still entitled to having habitable living conditions. Now, certainly we must be flexible to everyone, and we don't want to put landlords or maintenance crews in danger either. So depending on the nature of the habitability, I would say it's probably a good idea for us all to be flexible right now. But it is important to know and to remember that tenants do not lose any of their entitled protections under the statute just during this. And we should be mindful of landlords who may try to retaliate based on that. So I just want to put that out there. Next slide, please. Okay, so what might we see after the moratoriums end? Again, this is the high speculation point of the presentation, because we don't quite know yet. It's going to emerge, and we're going to, I'm going to try to highlight the ones that are, I think, the issues that we're most likely to see. But there certainly could be more and maybe less, but these are the ones most likely that we'll most likely see afterwards. So the first one is, a surge of eviction filings. It probably comes as no surprise to anyone listening here today that Indianapolis specifically has ranked pretty high, at least in the top 2 at one point, of eviction filings and evictions of metropolitan areas across the entire United States. So we already have a pretty high eviction rate here in Indiana. So now with this and with the pause of eviction filings, we're anticipating and trying to prepare for a surge. What we're hoping, I think what would work great for our, or what would help benefit our clients most, is public encouragement for landlords to work with tenants, because there certainly, again, are going to be a lot of tenants who are unable to pay rent due to the nature of losing their jobs, waiting for stimulus payments, potentially wrongfully being denied unemployment and having to wait on that. There's just a number of factors that happen. So, we want to really work with our partners and landlords and look at them as partners and trying to find, because I could be wrong, but I can't imagine that anyone really wants to see a giant eviction and be the state that has even bigger numbers for the COVID crisis. So I think there's motivation from all sides to try to do a reasonable solution. So that's the first one, is trying to work with the landlords. As far as rental assistance, this is something that is emerging, something that other groups that can work on. I was encouraged. I saw some notes about Congress working on the fourth COVID response package, and it seems that nationally advocates are pushing for rental assistance. And currently, I think it's HR 6314 in Congress, the Emergency Rental Assistance Act, is proposing $100 billion in emergency rental assistance. So that's emerging and can change regularly, but we're keeping our eyes on that. And even so, there may be other forms and other ways to get rental assistance through some of the stimulus. So that's something we're trying to just watch for and just be aware of if that becomes an option, because at this point, personally speaking, in our office, we've our social work, we have a social worker who works with our eviction avoidance project, who's been collecting just data from different community groups, including religious groups, that are collecting and offering to help subsidize people's, or help pay for people's rent during this crisis. So we're trying to just keep that going now, but we'll keep an eye out for those. Current kind of supports that we have in place, I guess, and we're building coalitions on to try to share the work and resource share. So the city of Indianapolis passed an ordinance earlier this year that provided funding for some new and already operating tenant assistance projects, and they've opened like 2 weeks ago, 3 weeks ago, I'm losing track of time, opened the Indianapolis Tenant Hotline. The number there is 317-327-2228, which I've been told is 2ACT. That makes it easier for anyone to remember. I don't know, but anyway, I put this on the slide on the slides a few times, so you guys can, so everyone on the call has time to write it down. This is something tenants can call to get some basic legal information, or some legal information about their tenancy and what's happening, and what this filters into eventually is these two projects we have here at ILS, which is the Tenant Legal Assistance Project, which is a new project that's just beginning. And then we have an eviction avoidance project that's been operating for almost 2 years now, and has had really great success when working with tenants, and really some good success in building some good bridges and coalitions with landlords, even to encourage settlements and working on pay and stays and things like that. Also, legal aid organizations, we are trying to work to get ahead of this as best we can, based on, again, the speculative things we think we might see. So we're trying to prepare in advance for this surge. Next slide, please. And in working with tenants, I just wanted to sort of highlight a few things just as I kind of wrap up here. The first one is just to remember those CARES Act protections that I talked about earlier. So specifically the timing requirement, knowing that, I just heard a story this morning, I think it came from our intake, of a landlord in a covered property sending a letter to a tenant saying that they were going to be evicted for not paying their April rent, and that once the moratorium was over, they'd be filing to evict. Well, according to the CARES Act, that's not correct timing. The notice could not be sent at this point until July 25th. So it's important to know that, and important to know the timing. Make sure that the notice requirement, the enhanced notice requirement, and looking into what the basis of the termination is. Is it related to non-payment? Is it related to something else? Those are just kind of the things we highlighted, or I highlighted as part of the CARES Act. So just to make sure that these heightened protections, again, in addition to the other protections that subsidized housing tenants have, to make sure that these heightened protections are enforced. The second, I've talked about it in the last slide too, is again, knowing private sources for rental assistance. I think we're sharing our document. We're trying to keep that that open so people can know who to go to and try to get some rental assistance. And then obviously we'll just, like I said, keep an eye on what the state or the federal government does as to potentially getting a rental assistance payment system or program in order. And again, I'll say this again, but helping to negotiate with landlords. You know, it's really going to, I think if we're going to be most successful with this, we're going to have to try our best to negotiate with the other side and to try to just get something reasonable. And again, I think there should be motivation in that, motivation from both sides to do that. My little legal note there, I guess, is to, if you're able to negotiate with the landlord at this point and say, hey, you know, I lost my job, you know, can I have 6 months from, you know, some date, you know, if you some date, or maybe I could have the whole year to pay off whatever debt I owe, give me till, you know, December 31st, 2020 or something like that. So anything you can get in advance is great. And I would just advise getting them in writing. And writing does not mean you need to have a formal contract signing of the agreement or anything like that. Frankly, a text message or an email acknowledgement and correspondence is fine. And that should be, that's sufficient just to sort of solidify what sort of agreement you're able to make with your landlord, or tenants are able to make with their landlord. And finally, if you want to go to the last slide, or second to last slide, I suppose. Oh, retaliation. You don't have to go back to that. I'll say I forgot about that one. The retaliation. Oh, sorry, Carrie. Thanks. With the city of Indianapolis's ordinance that they passed at the end of February, that makes Indianapolis, sorry, this is Indianapolis specific, has an anti-retaliation statute now. And in talking with our partners at the city of Indianapolis, I think that they are on the lookout and prepared to go forward with any sort of retaliation claims that maybe could be based on a landlord's adverse action during the COVID crisis. So I just wanted to address that for Indianapolis folks, but you may look and see, I don't know of any more, but if your city did any, or county did some additional protections. Okay, next slide, thanks. This is like the tenant resource. This is again, I know some of these have been throughout the presentation, but I wanted to just put them out here in one slide. Again, the hotline we've talked about. So the Indiana Attorney General has also put a special form up on their online consumer complaint section. So if any landlord is attempting to evict their tenant, which could be from sending a notice like I discussed earlier in the intake I saw this morning, or or take self-help eviction, or even attempts to file a case, and if they do it online with their attorney, the Indiana Attorney General is encouraging, and they're being very proactive about this, they're encouraging tenants to file consumer complaints on their website during the state of emergency. So that's a really, really helpful resource. Because this is a PowerPoint and I'm not, which you may have seen, I'm not the most tech savvy person, the link is a really long, ugly link. It's not some really cool, nice little link. So you have to Google it. I didn't put it on here, and I can, and maybe in a follow-up email or something, I can put the hyperlink to it. But that's the reason the link's not there. It's kind of one of those with a lot of backslashes and numbers, and I wouldn't have expected anyone to sit and write this down. So anyway, and again, finally, legal aid organizations. And I think, most importantly, at this point, again, what Prosperity is doing is, Prosperity Indiana is setting a great example. The most important thing we can all do right now is communicate and share resources. No one needs to reinvent the wheel. I think we're all in this for similar reasons and trying to help our Hoosier tenants. And so I think just being very transparent and open with resources and open communicating and participating and listening in these sort of presentations is just hopefully helpful to at least get to help you make everyone aware of what the rules are and what trends we're seeing. So I think that said, I put my email address because I think we're all remote now, and I don't even know what phone number you can call to get a hold of me anymore. So I just will put my email address, which isn't that a lovely way I did that. So if you have any questions, please feel free after this or in the days or weeks to come, please feel free to email me, and we can, let me know what you're seeing, even if it's just to give me a heads up, and that's something that I can help communicate to the partners that I work with, and trying to just get ahead of as many things as we can. So that being said, that completes my portion, but I think we have time for questions and things like that. I'll do my best to answer. Thank you.
Thank you, Brandon, for your presentation. We really appreciate it. We do have some written questions here, and I just want to remind folks that you can either type your question into the questions box, or you can raise your hand and ask your question. We'll unmute you, and you can ask your question directly to Brandon. So I'll begin with the written questions. First one comes from Abby Wiles, a lot of information was given regarding the covered properties under the CARES Act. Are all properties not covered under the CARES Act covered under Governor Holcomb's executive order?
Okay, yeah, that's a great question, a great point of clarification. So yes, Governor Holcomb's order extends to all, a moratorium or a pause on all eviction filings, whether private or subsidized. The CARES Act, those covered properties are the only ones that are covered and protected under the federal moratorium, as I understand it. So I hope that simplifies. This is a simple answer. Hopefully that works.
The next question comes from Cindy Benedict. For the state, non-federal properties, can they charge late fees or penalties?
So for non-covered properties under this, yes, the governor's order, as far as I'm aware, and again, there may be additional guidance coming, but at this point, as I understand it, yes. So for a private landlord-tenant situation, feasibly, landlords in Indiana could charge fees if it's not a covered property. I would say for that point, though, I would argue, or I would say, to tell tenants or to tell landlords, and if it unfortunately happens to go to court, I think there may be a strong public policy argument against doing that. And I think you could cite to the CARES Act as an example of what good policy is. But yes, as far as actually black letter law for that right now in Indiana, that's not there.
All right, and sort of a follow-up question to that is from Eric Kramer. How do we get information about not charging late fees?
I'm not sure if I told.
Where's the information available?
Oh, okay. So that's from that. I mean, that was direct language from the CARES Act. Maybe one place you could look, and a place that I use frequently for finding up-to-date resources is, first of all, our website, indianalegalservices.org. We have we're keeping our not just for housing, we do all a lot of basic needs. So you can look there because we were regularly updating our website, but also the National Housing Law Project is doing a really great job. They have like a 2-page or 3-page summary of the CARES Act and those specific protections that also highlight the covered properties. So if you want to look into that language a little bit deeper, I would maybe say look at one of our national partners, like the National Housing Law Project, if you can't find it on Indiana Legal Services website.
And another question comes from Liz. She says, I have a tenant who is using marijuana and the police were there and actually found the marijuana, the pipe, and the individual who was smoking it. They did not arrest her, but we are not a state where where this is legal and it's against our policies. Can I file a notice to vacate based on the marijuana use? It has affected other apartments with the smell, and the resident in question has made threats to the neighbor who reported this. Is that legal for her to file a notice to vacate? at this time?
Okay, that's a very, very specific question. I'm going to do my best to kind of broadly answer because I think I should, this is probably the most annoyingly lawyerly thing I'll say today, but it depends, and I have a lot of follow-up questions before I would give a specific answer to that. So I'll speak more broadly and generally, and hopefully, Liz, you'll find that helpful. So, I mean, the first question is whether it's a covered property. That sort of will dictate some of your timing questions as to when you could file a notice to quit. Now, again, the pause is this non-payment, but again, I think courts are going to be pretty lenient on that. I think, courts are going to follow that pretty strongly, I would say. As far as in Indiana, again, we are paused out, no eviction filings for any reason until at this point May 5th is the day that the executive order is over. So if it's not a covered property, I guess you could do the notice, but it would be it wouldn't be until May 5th, assuming that date sticks for the state of emergency. And I guess just to be broad and to answer a broad question is yes, any lease violation, tenants are still obligated to their lease violations, which include paying rent, but also the tenants during this time are obligated to follow the rules of the lease. That sounds like criminal activity that was not allowed. So you don't lose the claim. It's just a matter of timing on when you might be able to do so. So again, for Indiana, if it's a private property, at this point, it's not beginning until May 5th to file an eviction. But again, you may be subject to other regulations if it's a federally subsidized property that's covered under the CARES Act. Hopefully that helped.
This is a comment from Brady Ripperger. If anyone feels that they've been discriminated against or are especially having challenges with disability related needs during this time in their housing, please have them contact the Fair Housing Center of Central Indiana at 317-644-0673 and leave a voicemail.
Excellent. Yeah, that's great. That's the Fair Housing Center of Central Indiana is very active, very great, and very, very helpful. I did not get a chance to clear any community. They would have been here as a community partner, but I didn't have a chance to clear. But yeah, that's a great. If you're hearing discrimination, certainly call the FHCCI.
A question from Liz Laughlin. We have been talking about residential evictions. How does this apply to commercial leases?
That's a good question, and I have something I have an answer in my head because I've read. I believe it still applies. I'm not probably qualified to answer that. I don't work in commercial leases. I work really only with residential leases, so I think it applies as well. But I would defer that to asking someone else.
Sure. Great question, though. What about late fees that have been charged prior to the CARES Act but had not been paid by the tenant yet? This is from Margot Dever.
So I'm guessing that means late fees prior to March 27th. I guess theoretically, then those would be okay. I mean, I think I guess thinking this through, should this go to like a litigation situation, the language is going to be that if the tenant's able to say, well, I lost my job and due to the pandemic and things like that, that would be maybe a policy and persuasion to have a court void them. But I think from where the CARES Act stands now, at the current iteration of it, anything that happened prior to March 27th could theoretically be acceptable.
Very good. And which city of Indianapolis department does the tenant hotline fall under? I haven't seen the city push out the hotline publicly yet, at Jill Glavin.
I'm sorry, what was the first part of that question?
Which city of Indianapolis department does the tenant hotline fall under?
Oh, okay. Sorry. I believe it's under the Mayor's Action Center. I think that's who is operating and kind of fielding the calls. I think they've, if I understand correctly, and I'm not going to speak on behalf of the city, but I believe they've trained a couple operators to have the calls directed to the ones who have the specialized training uh, of knowing whether the tenant may qualify for the TLAP program or to provide some very basic information. I think the city of Indy has been on a few local news stations with it. I'm not positive, but yeah, I think it's kind of been a soft rollout. I think, Jill. I think that's probably the best way to say it. It's been a soft rollout, but we have had a number of tenants start to call it over the past few weeks, and I think just more information is going to be getting out about it. So thank you.
And I'm going to open it up. I think Liz Newton had wanted to ask a question specifically, so I'm unmuting you, Liz, so you can ask your question directly.
Thank you. I appreciate that. I'm the person that put the question, posed the question about the marijuana use at my property. It is a HUD subsidized property, so it is covered under the CARES Act. Everything I've read has dealt and has, surrounded the fact of non-payment of rent. And this person, the police have been called there twice. And I just hate to think I have to allow this person to stay there until July before I can give them a notice to vacate if they continue to disrupt the property and the people that live there.
Yeah, no, I certainly hear I see your perspective, and I know it's and you are correct. I mean, as I understand as well, it's related to non-payment of rent. If you've been a property manager for a while, you probably can know that sometimes tenants can, or there's always maybe some way to tie it to rent. But yeah, I mean, it sounds like a really tough situation, and again, it's something to balance. And I know that it's difficult with what's happening, if that's really if it's causing the property with police coming and and all that, the same in the same vein, to balance that with the concern of kicking someone out during a pandemic. And I think that really, yeah, with the CARES Act, I think that as far as, I mean, obviously whatever program the property is, so if you still have to follow the basic whatever notice requirements that program has, which may be minimal, but it is, yeah, the 30-day notice on the 25th would be if it was non-payment related. So I think the challenge you have at this point is in Indiana, there's no evictions at all, regardless of who, where, or why, until at least May 5th at this point. So right. At this point, you couldn't file until then. But as far as the federal moratorium, I think it's also going to be a little bit of keeping an eye on it, because obviously this was passed pretty quickly. And so keeping an eye on what, kind of like what other states might do if there are covered properties that start maybe trying to evict during the moratorium based on issues that are not non-payment. So as best I can say is it's stay tuned. I don't really have a great answer for you, Liz. I'm sorry, I don't have any more. That's just kind of like just the basic information I have.
Thank you. I appreciate it. I have reached out to my contract administrator at HUD, and she just gave me the same answer across the board. She didn't even elaborate on the lease violation. She just said for 120 days. And that was how she ended it. And I think there's just so many questions that really weren't addressed. And like you said, it came out quickly. And I understand the reasons why we don't want people moving around with this virus. And I do understand that. But at the same time, I have a neighbor that is frightened for her life because this woman continues to threaten her. And I just told her, continue to call the police if it happens. And I've just left it at that. But I appreciate your help. Thank you.
Yeah, no, I feel that, yeah, you're dealing with a really, sounds like a stressful situation and trying to manage it. So I appreciate you being thoughtful and trying to figure out the best thing to do here for all your residents. So thank you.
The next question is from Cindy Benedict, and it's for Prosperity Indiana. Is Prosperity Indiana advocating with the state to waive late fees and penalties for private landlords I'm going to put our policy director, Andrew Bradley, on the spot here. I'm going to open up his line to see if he could answer that.
Thanks for the question. What we're trying to do right now is we're still kind of in a fact-finding mode, and we're trying to see what are the resources that are available out there to put together recommendations for the state for rental assistance. And you can see the first iteration of that on our blog, on our website. We did make a recommendation to the governor and to the governor's staff to use some resources that are available in the CARES Act, including additional CDBG funds, as well as the emergency grants that are in the CARES Act for COVID response. We've received some guidance that those could be allowed for rental assistance. And we are also recommending that the state use this opportunity to use some of what has been called the rainy day funds. We have over $2 billion in rainy day funds. If there's ever been a rainy day, this is it. And we also think that this is an opportunity to use or to reform or at least reallocate some of the township poor relief funds that sometimes don't make it to those who are in need. So that's what we've come up with so far, but we are going back to work with some of our partners and to come up with a more detailed response, and starting to have some discussions also with state agency staff on thinking about how could we put this into place and perhaps also use a combination of federal, state, and third-party and private funds. So I'd encourage anybody who's on this call who's interested in being part of those conversations, feel free to reach out to us. My email address is abradley@prosperityindiana.org. You can feel free to reach out directly to me. And also there's the COVID resource email that is probably going to be put up along with the slides for this presentation. So thanks again for that question.
Thank you, Andrew. That looks like all the questions at this point. Actually, I think we have one more question from Liz Newton. Liz? Okay, I guess not. All right. Any other questions that folks have that they'd like to ask of Brandon?
And people are free to email me as well if that's easier. If you think of something a few days from now or something, I'm happy to try my best to get an answer for you.
Great. Okay, it looks like that's all of the questions we have, Brandon. We really appreciate everyone joining today, particularly Brandon for giving his expertise on this matter. And we thank the Indiana Legal Services as well for making this event possible, along with Fifth Third Bank. If you have any questions of Prosperity Indiana related to COVID-19, please email us at covid19response@prosperityindiana.org. You can also share resources with us, and those may be put up on the resource hub. So again, ladies and gentlemen, we want to thank everyone for joining us today. We want to let everyone know that we next Monday from 10 to 11 will have another webinar. This time it will be on leadership in times of stress. You can go to our website, www.prosperityindiana.org, and you will find it in the upcoming events page. Again, thanks everyone. Have a great day.